Hi, I'm Janice Switlo, and today I'm looking at a quote-unquote scholarly paper by Donald Swainson, Canada Annexes the West, Colonial Status Confirmed. This was published in 1978 by the Wilfrid Laurier University Press, Waterloo, and forms part of textbooks that are still actually taught today. And what I'm addressing here, pointing out, is the inaccuracies of perception as to what has transpired. So let me get to the quotes. For this recent study of Canadian Indians, comments, for the sake of convenience and recognizing the arbitrariness of the choice, we may use the date 1876, that of the first Indian Act, as the beginning of what we call the colonial period. From this point of view of the European, the Indian had become irrelevant. And explains that in terms of what was being set up here in Canada between the Crown and Indigenous nations. The Crown saw federation in mercantilistic terms. As children of the Empire as it existed prior to the repeal of the Corn Laws, it is not surprising that their federal model was the old colonial system modified to involve the citizens of the provinces in the government of the whole entity. The purpose of the Fathers of Confederation of Canada to found a united and integrated transcontinental dominion was comparable with that of the mercantiles, and in both designs there was the same need that the interests of the parts should be made subordinate to the interest of the whole. The Dominion was the heir in direct succession of the old colonial system. It was put in possession of both the economics and political controls of the old regime. On the one hand, it was given the power to regulate trade and commerce, which had been the chief economic prerogative of Great Britain. On the other hand, it was granted the right to nominate provincial governors, to review provincial legislation, and to disallow provincial acts. The three powers which had been the chief attributes of Great Britain's political supremacy. And federal management of the West during these years should be looked at in micro as well as macro terms, although it is clear that federal authorities had little interest in day-to-day Western conditions. If settlement was to proceed in orderly and rapid fashion, the Indian problem had to be solved. That task involved extinguishing Indian rights to the land and rendering the tribes harmless by herding them onto reserves. The instrument used for these purposes was the Indian, quote, treaty, end of quote. During the 1870s, a series of agreements was negotiated between the Crown and the prairie tribes. Through these treaties, the Indians gave up their rights to their traditional lands in return for reserves and nominal concessions, payments, and guarantees. However, they tended to resist being forced onto reserves as long as the buffalo, their traditional source of food, remained plentiful. By 1885, the buffalo were on the verge of extermination, and most Indians had been coerced to settle on reservations. So let's just set the facts straight. The treaties granted permissions. This was not a sale. This created a landlord-tenant-like relationship. This was not, and you'll notice how Indigenous nations and nationals are treated, as if they did not know what they were doing, as if they got nothing for their land. This kind of thing continues to be taught in universities. My source for these papers, the price tag on here is from the University of Regina. And this book, I think, is second edition, 1986. There's no reason to expect that that same set of papers are not still relied upon. They are. This is the core message. This is what worries me when they talk about, well, we're going to teach about treaties in schools. That's the kind of stuff that's taught, not the reality of what the treaties are. So this is what continues to be taught. Now, the aspect that the foundation for the relationship was commercial absolutely meets and matches what the treaties are. They're in there to have and to hold. The Crown decided not to engage in war to try to conquer, but rather to continue the foundation of economic development together. That sharing in the resources that allowed for successful relations. And unfortunately, how does, for instance, describing the relationship, the foundation there in those ways, as that author starts out, how does that turn into they gave away their land for trinkets? That's the part that, how do you go from one to the other? You really just don't. This is a person who has clearly been indoctrinated to believe that the treaties say something that they don't. It's the same old big lie, the position that comes out of Canada and provinces as to what the treaties actually are, with failing to specify that, for instance, standard in any commercial deal, any new agreement, you want to make sure, especially with land use permissions, you want to make sure that you're the head tenant. You don't want to go in and find out, wait a minute, someone else did a previous deal with these nations, and therefore my interests are beneath that nation. How do you ensure that? Well, the way you do it is you surrender all previous deals. And that's where you have these rights of use that are being given up. In other words, the people are moving over to allow for this other settlement, but that has nothing to do with underlying title, which remains in the hands of the Indigenous nations. So the use of the land remains governed by the law of the land, which is where the land is, which pre-exists the establishment of Canada and has not been terminated. Canada continues to try to do so. Canada continues to assert that what the Crown has is much more than what she actually does. And in doing so, the tactics that are used, which I try to demonstrate, result in Canada being an outlaw nation. So if we look at the transitions, it reflects a change of the use of the land. So for instance, Indigenous nations owning, controlling, using it all. So think of it like this. You have a owner of land, a store owner, he's running his own store. Now, what's happened since contact, since the introduction of treaties, is that instead of the Indigenous nation running its own store on its own land, it is now renting out the store and will get participation rent from others conducting their business and doing what they're doing inside that store. So now we have the situation that just because permissions have been granted, for instance, to someone else to use that property, to use that store, and on terms that require participation rent, which is standard in any commercial environment, now you have the tenants thinking that they're the owners and they don't have to pay rent, they don't have to pay participation rent. These lands, which are of these nations, always provide for these nations and their nationals, and will do so in the future. And the adaptation that takes place is how the land is used. The buffalo are gone. New ways will replace the buffalo, and have. But unfortunately, through these transitions, Canada, the provinces, have forgotten what's really the legal foundation here, and they want to change it. They want to take over the store, take over the land, keep it all for themselves. They have no lawful foundation to do this. They cannot, in this day and age, under international law, attempt this sort of coup, particularly where there are binding treaties in place. All Canada serves to do as an outlaw nation is to seriously undermine the interests of the Crown and thereby seriously threaten the stability of Canada and prevent Canada from nation building in a legal, lawful way. What that means is Canada does not abide by the rule of law. It abides by its own rules that it creates when it wants to. And that's all I have to say.